Let me start with the public official at our group, Blayne Stansberry. You'll see that she is a PE. Blayne is board president of the Barton Springs Edwards Aquifer Conservation District and a very experienced civil engineer. She has recently decided to become a professional educator. This year she is starting as a high school math teacher, so we're excited about that. Stacey Reese, water attorney like myself, Dr. Bill Hutchison, a PE, a professional engineer and a PG, and Jim Totten, general manager of the Lost Pines Groundwater District. Please look at the bios in the brochure for more about their distinguished careers and background. So we are not here to advocate how to get a permit, and we are not here how to advocate how to defeat a permit. We're here to talk about how you might avoid the fight, and sprinkled throughout our discussion, we'll talk about times that it's appropriate for district representatives, the applicant and protestants to talk informally and try to reach agreement to avoid the fight. We're also going to tell you that if you got to get into the fight, some ideas about how to win it, and from different perspectives. So with that, let me launch. If we could turn to the next slide, please. So, as I mentioned, our goals are to share with you the process and tips, and we'll have some takeaways for the process. As far as the law governing permitting and hearings, the law is Chapter 36 of the Water Code for the most part. Subchapter M has a lot of the procedures, and 36.113 and several of the statutes that follow that section provide for a lot of the meat of how you go about the permitting process. Next slide, please. So let's talk about the applicant's view. You're a landowner, or you have some interest in groundwater, and you need to drill a well, or you need to produce water from and operate a well. For our purposes, we're going to be talking about large volume transfers, not 100 acre feet. We're going to talk in relative terms, but we're talking about large volumes, where it's presumed that the folks involved from all angles, whether they're folks concerned, the applicant or the district, are looking at thousands of acre feet, billions of gallons of water that would be pumped per year. So I'd like to start with Dr. Hutchison. And Dr. Hutchison has worked for a variety of the types of stakeholders. Dr. Hutchison, if you're working for an applicant, what are the types of things that you're counseling that client to do before the application is filed?
Well, before the application is filed, you basically want to look at both regional data and information and local data and information. So regional can include GAMS, DFC explanatory reports, those kinds of things, and the historical geologic reports. On a local scale, now you're getting into details on data. We heard a good session the other day on data. The Texas Water Development Board database is unmatched in the country as far as availability of good information that you can rely on in terms of water levels, water quality, well locations, well depths, that sort of thing. So it's really just a matter of, depending on your objectives, focusing either on local or regional or both, and then doing your homework.
What about district information and coordination with the district on data that they have?
Yeah, most districts will have lots of good information also. Just as a default though, a lot of that information already gets rolled into the Texas Water Development Board database. So there's, I always start with the Water Development Board database and then supplement it with what other detailed information there may be at the district level.
Let's get some legal advice as well. So Stacey, most districts have application forms, they have rules that govern the process, and there are minimal requirements that have to be met. What are your thoughts on counseling any applicant on meeting those minimal requirements or going above and beyond to providing a more robust application?
Sure. First and foremost, we start with, okay, what are the permitting rules? We need to have a thorough understanding of those. What are the application requirements, which, as Mike mentioned, are very specific, enumerated, general types of things. And then there's a catch-all that allows the district to ask for other information. And if they want to ask for other information, it needs to be in the rule. Typically, that could be something like a hydrogeological report, where they're looking for an assessment of impacts that your proposed project is going to have on nearby landowners or wells. So even if it's not required under the other information, sometimes it's important to consider doing a hydro report, even if it's not a technical requirement, because there, in another section of Chapter 36, there are considerations that the GCD board must make before they're granting and denying a permit. And those considerations in a contested case hearing situation effectively end up becoming the applicant's burden of proof to establish that they're entitled to receive the permit. And one of those requirements relates to whether or not the proposed use of the project has an unreasonable effect on groundwater and surface water resources and existing permit holders. So even if you're not required to show an analysis of impacts as part of the application process, if you've got a big project, you think it's going to be protested, I talk with my client about whether you need to go talk to Dr. Hutchison or another technical consultant to get this analysis impact, because ultimately that's going to be something that you're going to have to prove.
Yeah, that's great. So Jim, in your capacity as the general manager, surely you're getting the call, somebody's dropping into your office to visit about an application, making sure they've got the forms. How do you make yourself available, and what do you find helpful for somebody who's wanting to apply to do in engaging with you?
Well, since we've limited the conversation to large permits, unfortunately I'm going to say that I don't really get that kind of interaction. Most of the time it's smaller operations and smaller permits. The larger permit applications tend to have experts and lawyers on staff that, I guess, take care of everything in advance, so they don't feel the need to compare notes with the general manager. We have had a case in the past where a large application walked through the door, dropped everything off, not realizing that 2 months previously we had changed the forms for the district, and so the application was immediately out and refiled, but a simple visit could have cleared that up before they filed.
So it sounds like implied in your answer is a tip. Call Jim.
Possibly, yes.
Blayne, as an elected board member, you and your directors set policy, you adopt the rules that govern this. You rely on your team, like Jim, to deal with the forms, which are important issues. So from a policy perspective, making a judgment call on how you're going to burden folks that want a lot of water from your district, which the burden would be providing technical information, doing the types of the hydrogeologic reports that Dr. Hutchison and Stacey mentioned. And what are your thoughts on in balance, in burdening an applicant versus what's important for your board to know to be able to address the criteria that Stacey mentioned? What are your views on that?
Well, sure. The Edwards is special, so we have multiple pages of rules that we have adopted. The Edwards really needs that live data feedback with a test, a hydrogeologic test. So we require a test well to be drilled. We require it to have live data and a report submitted with the application that the applicant provides. We have on-staff PGs that review this application. And this is because the karst nature of the Edwards doesn't respond well to like a desktop study. So we do have to require that investment so that we can really get a good scientific basis of what those potential impacts from their application could be. And then the GM bases their preliminary decision on that science.
Yeah, thanks. Dr. Hutchison, could you share your experience, a couple of districts I'd like to call out and allow you to brag a little bit about, the Bluebonnet District and its two-phase approach to permitting, how that's been useful for all involved, the applicant, staff, the board, and folks who are concerned about impacts from those applications?
Yeah, right. We've heard a little bit from Blayne about the need for a test well in something like the Edwards Aquifer. In the Gulf Coast Aquifer, we don't see that as critical a first step. So our first step in the Bluebonnet District, which is the Gulf Coast Aquifer area northwest of Houston, we require essentially a paper study that focuses on regional impacts of the proposed pumping. And so following the guidelines that we've developed over the years and evolved over the years as we've learned more about the process, what's the most streamlined way to do the process, we require essentially a model simulation that adds the pumping to the current DFC run, so then we can compare with and without, the incremental impact of that well. We find that to be useful as sort of baseline information to be included with the notice of the permit application, to give adjacent landowners just basic information on what the long-term impacts of that pumping would be. That's then followed up by, assuming the permit is issued, then the hole is drilled, the well is tested, and then there's a phase 2 report that's required that focuses more on the local issues. So essentially we start with the regional paper study to give just basic information, then followed by the actual construction of the well and the test of the well, and then that's part of the phase 2 report, which reports on everything that was done as part of the drilling and testing of the well, and then compares that back to the paper study to see if there's consistency on that. And that provides information to the district to update models and processes. It also feeds into the DFC process. So it's a very useful, streamlined approach that actually gets information not only to the district but to the adjacent landowners to make a decision on whether they should protest it or not.
So you have another client in West Texas, the Middle Pecos Groundwater Conservation District. Similar two-step approach, not as formal. Could you describe how that's been helpful?
Right, so just like we talked about, or Blayne talked about the need to have a well because it's in a karstic environment, and we don't need to have that in the Gulf Coast aquifer. Out in West Texas, we do. We wanted to get some, we issued drilling permits in order to drill the well to see if the site will actually produce water. And so we're not wasting a lot of time processing permit applications for a site that just won't yield the amount of water the applicant wants. So the first step is drill the well, test it, prove up the supply, and then get the permit, the actual production permit.
So let's turn it back to Jim Totten. The ball has landed in your court. The application's been filed. And it isn't your board that takes that next step, you take that next step. Could you describe what happens once you've received the application? How you coordinate with your team, both inside your office as well as your experts that you work with, your hydrogeologists?
Our normal process is pretty straightforward. We kind of follow a two-track process, one of which is all the hydrogeologic information goes out to our consultants there to review, start doing model runs and developing some impact analysis. At the same time, the remainder of the application gets split over to our attorneys. I'll work with the attorneys to go through and make sure that they do have an administratively complete application, verifying the information needed, working with the applicant to get more information if there is a deficiency that needs to be addressed. And then hopefully by the time we get done with that, the hydrologic studies have been done. We can come back and figure out how to proceed with the application from there.
So the application at some point gets declared administratively complete. Those minimal requirements are met. And the statute's pretty clear about then what happens and a timeline for getting notice out. Stacey, could you talk a little bit about that notice, briefly about the 10-day notice, and then how districts have discretion if they want to provide more notice to get out to the public?
Sure. So for a hearing on the permit application, the GCD is required to provide at least 10 days notice. They can provide more, so there's some discretion there. That's really just a policy decision. You have to balance the interests of the general public who wants, more time and more notice versus the applicant who, is likely not going to want to have an extended period of time for notice, leading into this hearing on their application where it gives people a chance to, sort of formalize and plan and get together and figure out how they're going to, attack the application. So you have to kind of balance those competing interests. There's also, not required by statute, but you can, and some districts do, provide notice of the application once it's filed, which is not required by the statute. There was a bill last session, Senate Bill 152, that incorporated that, where GCDs who had spacing rules were required to provide notice of the application once it's filed to certain landowners in certain circumstances. So I think we expect to see that bill come forward again, but until it becomes a law, that's sort of just a policy decision for the district as to whether they want to go ahead and provide notice of the application.
Thanks, Stacey. So Jim, back to you. So whether it's 10 days notice or a little bit more, at some point the public becomes aware of the application. And your phone starts ringing, and your texts start rolling in, and people start showing up at your office. I believe your district also posts large volume applications on the webpage, I believe, in some cases. Some districts do. How do you handle the incoming calls and the concerns of the public?
It kind of depends on the questions that are coming in. By the time that we get to the notice being posted, we've done our own hydrologic studies. We have any data that was supplied by the applicant. So I can pull from those sources to try and address any concerns that come up. I also have, the reports from our attorneys as well that we can kind of reference. Anything that gets beyond that, there's the standard, I don't know, I'll have to get back to you, which seems to work fairly well. Or in extreme cases, there's always the phone number for the applicant's attorney that I can give out too.
And so let's talk about that. Stacey, put yourself in the shoes of the applicant's lawyer. Jim's giving out your number or your client's number, and you're getting that call, 5 days, 6 days before the hearing, the big event at Blayne's show, her board meeting. We'll get back to that. What is your advice to your client on how you're engaging with potential protestants?
I think first it's like, take a deep breath. We're going to get through this. We're going to hope for the best, but plan for the worst. But all kidding aside, I think a lot of it has to do with managing, at least my advice to my clients is managing their expectations about what's going to happen, the process. There's going to be some pushback. There's going to be concern. You need to figure out how you want to address that. Hopefully you've hired other professionals such as, technical professionals who might be able to provide information. Sometimes I think that there can be a frenzy because people don't have the information or there's misinformation out there. So sometimes it can be helpful and I'll, discuss with my clients, you might want to put some of this information out there. You might want to hold some, town hall meetings if there's a big group. You might want to talk to people one-on-one. Sometimes it's not effective to do that. Sometimes it's helpful for just the lawyers to talk about different things. But first and foremost, you need to have a plan. There's going to be public concern for these big projects. You need to expect it. You need to not take it personally. You need to be respectful and professional. And don't be a jerk in this. And let's try to work through it together.
So I've seen some matters resolved before we get to Blayne's board meeting. Jim, it's my observation, my experience, that often it's the general manager that's encouraging engagement between concerned citizens and you and the applicant. What are your thoughts on that role that you can play before the board meeting day?
I've certainly in the past tried to encourage applicants that have contentious permits to get out there and be their own advocates. The district's job is not to advocate for any particular application or any particular applicant. If you know there's going to be a public issue or public concern, then it's incumbent upon the applicant to try and get out there and help address some of those issues. As the GM, any information I can supply to kind of work in that process is certainly something we'd like to do, but ultimately a lot of it is incumbent upon the applicants to try and help sort that out for themselves.
Yeah, so Blayne, word's out on the street about the application. Your board meeting has been publicly noticed two times under the Open Meetings Act and under this 10-day notice. You're an elected official. Your constituent may be the applicant, and your constituents may include concerned constituents, and your phone starts ringing. How do you manage that? What is your experience?
Ooh, that is such a fine line to walk. First of all, we include a 20-day comment period when we submit the notice, and that is a strategic step that we take because it is a formal way that we can gather in the comments. And by the time it comes to that public hearing, we typically know if the application is going to be contested. We typically know if a request for a SOA referral has been made. So this is all good information we have before we get to the actual hearing. But if my phone starts ringing and I have a sense that that case is going to be contested, then I have to let my constituent know that, as a board member, I'm one of 5 people that are going to be the final decision makers in this hearing. We are in fact the judge, and I cannot talk about this case. Otherwise, I could jeopardize my ability to act on a final decision. So I refer them to the general manager.
So Stacey, the legislature has told districts you've got some discretion in how you recognize the opportunity for folks to protest. And I'd like for you to focus on the deadline. There is discretion to set a deadline to protest that's before or at the hearing. What are your views on that, from the district's perspective as well as those other perspectives from the other stakeholders?
Sure. You can do it well in advance of the hearing on the application. You can set the deadline to notify that you're going to protest the application. You could set it for at the hearing. You're also required to set a deadline for requesting the case to be referred to SOA as well, and you can do that before the hearing or at the hearing. I think doing it in advance, requiring it in advance is really helpful for the reasons that Blayne discussed, because you're going into it and you already know who's going to protest and who's requesting an application. You don't know yet whether those protestants are going to ultimately be parties in the case, because there's a standing analysis that has to be done later, but at least you know who's interested. And so I think it helps you get more organized. I also think there's some downsides to doing it, in advance, because sometimes people don't have enough information to determine whether they want to protest. And so they may protest out of an abundance of caution to not waive their right. And then sometimes, while they can then later withdraw the request, sometimes what happens with these big applications is you get a bit of a frenzy going on. And so one person files a request for a protest and then many do. And then even if the original person, withdraws the application, you're still got all these other folks involved. So there are pros and cons to doing it early or doing it at the hearing, but I think the important thing is to understand the pros and cons and develop a system that works for you.
Yeah, good. So it's board meeting day, and the ball's back in the court of Madam Chairwoman, back to Blayne. You're in charge. Chapter 36 of the Water Code says, the board is there, they've got your back, they're with you, but you are the presiding officer as the board president. And so and it's very express in the statute that there are certain decisions that you alone can make. You have options for how you want to manage, which with a large volume application, maybe chaos out in the parking lot. When they walk through your door, you have some ability to control, with your staff's help, how things look, what information is available, what guidance you're sharing, you're having your staff share informally. But then you call the meeting to order, and then you call the hearing to order. In your experience, what's been the best approach to manage a large volume application?
So in this kind of first hearing, we treat it more as a preliminary hearing. We've had our comments come in, we've got a sense of what's going on, and that the case is going to be contested. And so we take that opportunity to explain the process to the public, that if this case is contested, this is going to a formal hearing, and the board needs to decide how that is going to be heard, how the hearing is going to take place. And so that there's several options that we're going to get into that the board can decide. But also at this preliminary hearing, people like to be heard. And so I usually entertain an ordered public comment where we have people sign up to speak. They're limited in their time that they can offer comments. But with contested cases, it's a little tricky in that sometimes the board can't consider the public comments in the final decision. So I would need to refer to our attorney to help inform the public of how their comments will be part of this application. But at least they know somebody heard them. But it does have to be very, very ordered. The facility needs to be big enough. Typically, you can change, if you know it's contested, you have enough warning to find a larger facility if you need to. But that's normally how we handle it. But the big decision on the board that day is what of the three options for this hearing are we going to do?
So, Stacey, you are often sitting to the left or the right of the board president and whispering back and forth about how it's going. Before that, you all have certainly talked about how it's going to go. What are your thoughts from the lawyer's view?
Are you talking about the hearing before the GCD board?
Well, the day of the board meeting, the preliminary
Sure.
hearing, the main event, and how procedurally it's managed.
It needs to be organized. When all else fails, a continuance is always a good thing to do. If you're not organized, you get caught off guard or you're surprised that continuances are allowed. You don't have to provide notice of the hearing again if you do continue the hearing. You can, decide at the hearing when you're going to reset it and tell the public at that time, hey, we're going to continue it for this date and time. If you don't announce that at the hearing, then you can then later you're required to notify the parties in writing of when the date and time will occur of the continued hearing. I think it's helpful that, you can be sitting next to the president and maybe kind of acting as the co-presiding officer and answering questions. If you get standing questions, you're going to be discussing that.
And if you could elaborate on that, the timing of deciding whether the board wants to decide the party status issue, when, and how they go about that.
Sure. So before you can, conduct the contested case hearing, you need to decide who's going to be parties to the hearing. And you have these people who have filed these requests to be, contest the application and be a party. But you have to determine before you can convene the actual contested case whether or not they meet the requirement to do that. And so we shorthandedly call that standing. It's a legal test, and you have to have a justiciable interest that's within the jurisdiction, related to a right that's within the jurisdiction of the district, and that's not common to the public, basically. And the GCD can decide that issue on their own, or ultimately, if the case is going to be referred to SOA, they can let SOA decide that issue. Because it involves a legal test, you basically have the elements of the legal test and what the law is, and then you have to look at each protestant and say, okay, what are your facts related to this test? And then you have to apply the facts to the law and then decide whether or not they've met that standard. So sometimes it's helpful to have that established at SOA because there is a lot of, analysis of the law and the application of the law to the facts, which directors don't necessarily feel comfortable doing. If they appoint a hearing examiner to conduct the hearing, that hearing examiner, would make that determination and might have more of the expertise or skill set to do that.
Yeah, so good segue here. Most applications are heard by the board of directors. In my experience, that's usually how it goes. We know that Chapter 36 gives districts some discretion not to burden the board or to hire a hearings examiner to conduct the hearing. And we're not talking about a hearings examiner, an administrative law judge at the State Office of Administrative Hearings. We're talking about a private hearings examiner. Chapter 36 says that. Or we can go to what we'll be referring to as SOA. I'd like to open it up for the panel. I know a number of y'all have experience doing it a variety of ways. And so I'll open it up for y'all to talk about some of the pros and cons of doing it before the board or going to SOA, or what's rare, at least in my experience, bringing in a hearings examiner.
Well, I'll go first. The This is what I was talking about. The board needs to decide at that preliminary hearing. These 3 different paths that are all so very different, and they are going to impact so many people's time, and it's going to cost money. I mean, the first one is the board doing it themselves. There is so much legal stuff. It's like an entirely different language, in my opinion. And so for the board to conduct that hearing, I've got to have an attorney right there by my side the entire time, explaining all of the different terms, all of the different processes, all of the different steps. Constant feedback on what is going on, and really just holding my hand through that process. As you know, I am not an attorney, but this is a very legal process. And so the board needs to pay for that attorney, which is going to be a lot of time on the board, the entire board, to hear evidence, to do the process. And that's going to be a lot of time on the board and a lot of money for the board. And it's also a contested case in any process is going to be a lot of time on staff. That's just a given. The second step is the hearings examiner, where that takes the time burden off of the board, because the hearings examiner would have experience with that and would conduct the hearing and provide a recommendation back to the board. But that's still going to cost the board a lot of money, because you're paying for an attorney at their regular hourly rate. The third option is the SOA option, where the administrative law judge takes in all the evidence, conducts the hearing, all the steps, and provides a proposal for decision back to the board. That one is basically SOA doing all of the work at a relatively reasonable rate.
For all the reasons, I think that was an excellent explanation. I think it's time intensive for staff. It involves a lot of legal stuff. You're going to be paying lawyers and consultants anyway. So, going to the SOA venue can be helpful. It was enacted originally to provide an impartial venue for people to resolve these disputes. I think it's really helpful for the board, because, they're not facing all this political pressure from their constituents about what you're going to do about this. Are you going to rule on my standing? Are you going to tell me I can't have a seat at the table? Or are you going to rule against me in my application? So I think having it removed to SOA, having an ALJ who's experienced in making all of these decisions and weighing the evidence is very helpful. When the PFD or proposal for decision comes back to the board, if you do go to SOA, the board can only change that PFD in limited circumstances. And so you're in this impartial venue. You have all the people who have the expertise in this area to develop the record, which, by the way, the record is what will be used in an appeal. So the record becomes extremely important in this process, because if the application is appealed, you cannot put on new evidence in the appeal. You only have the record from the hearing. And so it becomes very important what type of evidence is submitted, who it's submitted by, if contrary evidence is submitted to rebut weaknesses in your case. So all of that becomes extremely important. And when it comes back to the GCD from SOA, they can only change it in limited circumstances. So, in my mind, I think it gives the GCD board some cover, because they can't, they're confined and limited, and they kind of have to follow what the ALJ says, except in unique circumstances. And I think that the applicant, feels more comfortable with this impartial venue, with these people who are, do this every day. And I think the protestants appreciate kind of the formal structure of it and their ability to really be heard, and it not sort of be, less structured and less formal. Not that the districts aren't capable of doing it, but I just think there are a lot of considerations.
Yeah, and there are a lot. And there are pros and cons. And I'd like to look at some of the cons. Jim and Bill, they're dragging you over to SOA, which means you guys are the only two on this panel who get to take the stand and sworn in and do all the things involving getting deposed and getting cross-examined. With all seriousness, I'd like to hear from both of y'all about time commitment. We know, we can cover this quickly. You're before the board, and you may be in and out in some districts, even with a large volume permit application, in a matter of months, a handful of months. That is possible, even with a large volume application. We know that you're not going to get through the process at SOA in a handful of months. It's a time-intensive process that has some expense. I'll stop talking. You all comment on your experiences doing it both ways. I know, Bill, you've had experiences both ways, and Jim, I think you have as well, but primarily at SOA.
Go ahead, Bill.
Yeah, obviously, the more formal the process, the more time it takes. I mean, that's just sort of axiomatic. If you are developing, from a technical perspective, if you've developed reports, those are useful in either a formal or informal setting. So a lot of the preparatory work really shouldn't matter whether it's going to be a big deal formal SOA hearing or a hearing in front of the GCD board, because you're still, at least from a technical perspective, your responsibility is to provide information that is useful in the decision. Part and parcel of that is understanding what the where the protests are coming from. What are their issues? Is there something legitimate about a particular set of wells or nearby property owners, or is it something related to impacts on a spring or a river? You know, those kinds of things. You need to know what those elements are of the protests, and so your analysis can be tailored to answer the question.
Anything to add to that, Jim?
Yeah. All of my experience has been through SOA. We've never actually used a hearings examiner or conducted the hearings through the board. I will say that in working through that process, it is time consuming, but the ability to develop pre-filed testimony, I think, is absolutely critical to moving things along a little bit more quickly. The ability for every party to file their written testimony well in advance just makes things a little bit more smooth and a little bit take some of the surprises out of things.
Let's talk about the handoff from the district to SOA. So somebody's requested, or the board has decided that we're going to SOA. Stacey, I'd like to combine a couple of questions that involve what that handoff looks like. Chapter 36 says that a district can, adopt rules that SOA has to follow, and I'd like for you to address that. And then second, Chapter 36 also says that a district isn't supposed to micromanage what the ALJ, the administrative law judges, are doing at SOA, but they can provide information to SOA. They can provide the rules, they can provide policy. I believe that includes sharing information about district precedent. Thoughts on what that handoff looks like and what you would counsel your groundwater district's board to do in making that referral?
So with respect to the first part of your question about developing rules specific to SOA, whether the GCD should do that, Chapter 36 allows you to do that, but your rules have to be consistent with the SOA rules, basically. Provisions of the Administrative Procedure Act that are incorporated in Chapter 36. So I think if this is your first time going to SOA as a GCD, I don't think you're going to know what rules you might want to have that, sort of complement the SOA rules. But if you're really experienced like Jim and Blayne, it might make sense for your GCD to do that. I'm not sure doing it sort of preemptively is necessarily something that I would recommend, but I think if there are lessons learned, it might make sense later to incorporate having your own rules about specific procedures at SOA. And if you don't have them, then you just follow the regular rules at SOA. Your second question was, politely remind me again.
Yeah, precedent, policies, information that you can share with SOA. And the statute's clear, it has to be on the front end. Not supposed to influence the judges, and so before a judge is even assigned, there's interaction between the district and the administrative team at SOA, and there's a handoff of what information that the district wants to share. Thoughts on that?
I think it's important from the district perspective, most certainly. It can be your rules, it can be policies, and it can be decisions or precedent. And, in all of the contested cases I've worked on, those all become an issue. What are the district's rules? What were the district's rules at the time the application was filed? What does that rule say? We're going to get into the details of all of that. How has the district handled this situation in the past? Are there written policies on it, or are there practices about it? And what precedent do we have? So I think it's an opportunity for the district to educate the ALJ and give them a preview of, sort of not ultimately their position, but what's the framework within which you're going to be making this decision. And a lot of ALJs, so we have more now who are more familiar with groundwater permit application contests, but when this first started and was put in the statute, there were no ALJs who had any experience. So I think that was hugely helpful to them. We have ALJs who are more educated about groundwater permit applications. Of course, they're very educated about process and procedure, but the nuances of a groundwater permit application versus some other application that a regulator has authority over is very different. So I think it's important, and you should certainly take advantage of that. And if you don't put it in the record and give it, then it's not going to be available to talk about.
Yeah, could we get some help moving to the next slide, please? So we're going to dig in a little bit harder on what SOA procedure and the mechanics look like. But first, I'd like to talk about the types of hearings that many of the districts around the state are having before the board. So the contested case hearing itself can be short. It can happen the day of the board meeting that we've just briefly described. Or it can be continued. As Stacey mentioned, might be agreed to by everyone in the room. Folks need to get organized. It can be informal. It can be formal. Blayne has some options in how she decides on the fly as she's seeing who's showing up that day, what the best approach is going to be. If there's not going to be a continuance and everybody is ready to move on, how to manage what that looks like. So what I'd like to do, I'd like to start with Bill. Bill has experience with really formal and less formal hearings before boards. So if you could share your experience, and let's focus on, as a scientist, whether you're a PG, a PE, or somebody that's a lay witness, knows a lot about their water and their well, what you do to persuade the board of your position. You're needing to put a case on the merits on. So what are you doing to get organized, and what is your counsel to your client to be ready to roll the day of the board meeting?
Yeah, in the more informal ones where it's a relatively small amount of water and it's just going to be, the hearing is going to be that day, whether it's contested or uncontested, a lot of the issue comes down to, is this well going to cause an impact? And then also, in other areas, you may wind up with a question related to the amount of water that's being produced on a per acre basis for their parcel that they own. So those are two kind of not unrelated questions, but somewhat different. From a impact assessment, recognizing that, what other permits have been issued by that district and understanding what they look at in terms of what is a reasonable or unreasonable impact, being prepared to answer those kinds of questions, being able to answer questions about, well, this is X number of acre feet over a certain number of acres, how does that compare to other permits in the area? So it's really, from a technical standpoint, it's really about doing homework and understanding what has been processed and approved in the past in order to answer questions effectively.
Yeah, so Stacey, what Bill is talking about is he's going to be sworn in, and he's going to have something to say that you and I call the record. The record that at some day our Texas Supreme Court justices might be looking at, deciding whether it was convincing or whether an expert's thoughts on the matter support what Dr. Hutchison has to say. Talk to us about what the record looks like. And in the simplest of ways, I mean, our boards, they've got to turn on the digital recording or have a court reporter or have somebody taking minutes. So talk to us both fundamentally about having the record, and then your advice from everybody in the room's perspective on the importance of that record as you move through other legal steps.
And and I'll focus kind of in an informal before the GCD board, because it's really well established and kind of not going to not happen. There's going to be a record. But at the GCD level, you want to make sure that, before witnesses start testifying, that they're sworn in. There needs to be a record. You want to make sure that there's a court reporter, that there's, it's being recorded, or someone's taking minutes, because that record then closes at the end of the final hearing. And then if there's an appeal, it gets, requested and provided to the district court who is hearing the appeal. And that is the record. And you go back and you look at it. And if what isn't in there doesn't, can't be considered. So very important. I think that the presiding officer, whoever that ends up being, if it's the board president or if they have appointed a hearing examiner acting as the presiding officer, it's really important for that presiding officer to know what their powers are. And Chapter 36 specifically lists, these are the, the duties and powers of the presiding officer in terms of considering evidence. You can exclude evidence that is not relevant, evidence that is repetitious. So there's a way to not overwhelm the record, but at the same time, there's certain, practice like policies and procedures that need to be followed. And those are all listed in Chapter 36 about limiting the evidence, how much you want, what types of discovery. I guess in the hearing right on the day of, you're not necessarily going to have a lot of discovery. So, but simpler is better. But have a plan.
Right. So, Blayne, Jim, your large volume applications probably going to SOA. But if you could share your thoughts, assuming that we were going to move forward on the board with the board, if there's anything that you think might be helpful. To provide some efficiencies in getting everybody in the room kind of down the road and comfortable that there was due process, that there was fairness in the proceeding.
So for that question, it's not so much about what the other parties need to do to be prepared. It's about what I need to do to be prepared. And so in advance of that, I would need one-on-one counsel conversation with the attorney so that we could, create this outline of how these steps are going to go. So my preparation is the key for me from a board perspective.
Yeah, that's good. I don't know if you have anything to add, Jim?
Luckily, I don't. That is a challenge for the board to try and wade through, and that's typically why we do send things out to SOA, just to avoid having to figure that out for us.
So let's take it to SOA, and let's talk about the preparation if we're headed to SOA. We all know that that first preliminary hearing before SOA is not likely to be any sooner, any earlier than 2 months. It could be longer. There is some internal coordination at SOA about how the case is going to be managed, who's going to handle it, where the hearing is going to be, because it could be within your district's boundaries. It could be back at Austin. And so, Stacey, I'd like for you to spend a little bit of time talking about, with that time that you've got, months, you've got several weeks to prepare, what your district's general manager, what your applicant, what the protestants are thinking about with the time that they've got to get prepared.
Right, and so typically at the preliminary hearing, if the standing hasn't been decided at the district level, that's something that is a threshold issue that would be handled typically by the ALJ at a preliminary hearing. But leading up to that, in this 2-month period, you're kind of figuring out, okay, what do I need to prove if I'm the applicant? What are my elements? What's my burden of proof? What evidence do I have for all of that? Who am I going to use to testify about these things? Who's going to be my expert? Who's going to be my lay witness? And from the district side, really from the district applicant and protestant side, you're all trying to figure out, what do I need to prove? What's the other person going to say? How do I need to gather all of my evidence and get ready? And then you'll have the preliminary hearing, and standing may be addressed at that hearing or at a later hearing. And you'll kind of talk about logistically about, any limits on discovery that's going to happen. When you're preparing for the preliminary hearing, you'll hopefully notice that you don't have evidence on certain things that you need to prove. And you're like, okay, well, I need to make sure that I get that in discovery, and what type of discovery will I need to conduct to get that evidence. And so then at the preliminary hearing, you might take up standing, you might not. Typically, you talk to the judge about, logistics of scheduling the merits hearing, what limitations should be placed on discovery, if any, and then when you're going to schedule that.
So, Jim, you're on your way to SOA without your board of directors. That relationship has changed a little bit in as much as you're now a party. At your district, you always participate actively as a party in those SOA proceedings, and you've disengaged with your board that will sit as the ultimate decision maker once SOA has made its recommendation. So you're in charge of your case. If Stacey's working for you, is your lawyer, she's working for you, and Bill's working for you if he's the expert. How do you manage that, knowing what you know, going into it and having a little bit of time to get organized? How are you working with your attorney and your experts?
So there's kind of a couple of tracks that go on, during those initial months. If we do think that there's going to be discovery on my end, and within the district staff, we start trying to pull together anything that we think might be sought through discovery, just so we have it prepared and ready. Similarly, like Stacey noted, you're working with the experts to try and figure out what testimony we need, what evidence we're likely to need. But really, the biggest part is, like I say, from the district staff perspective, you're doing double duty of preparing like a witness, but also trying to manage the logistics of getting the case, getting everything into SOA, getting the contracts signed and finalized, and then, finishing up your preparation from there. And then, of course, as you mentioned, being a separate party from the board, you may also have to be tracking down legal representation for either for yourself or for your board throughout that process. So there's during those initial months, there's a lot of things that have to kind of be taken care of and sorted out at the district level.
So Bill, you have quite a bit of experience working with general managers and through that SOA process. What would you add to Jim's observations? What are the things that you're typically doing or enhancing what you've already done in order to prepare to be deposed in a deposition, to work with the lawyers at some point on pre-filed testimony? What are the types of things that you're doing?
Yeah, those are the key elements are expert reports, depositions, anything related to getting prepared. The pre-file testimony is useful to sort of streamline the process, but it does have a big disadvantage from a technical perspective because you're not always able to convey the technical analysis appropriately. And so I always try and push for some sort of technical report or expert report that can actually lay out the analysis or the answers to the questions in a more concise way that sometimes pre-filed testimony can't capture.
Yeah, and let's talk about that work product for just a little bit. I think it'd be helpful for the people in the room to know that we've left the Groundwater District and the board that knows something about the Aquifer. And we've usually gone to Austin. There's some discretion on where we are, but we're with Austin-based administrative law judges, many of whom aren't living groundwater. And what are your thoughts about how you're conveying information about an aquifer that they may not have heard of? And these permitting criteria that Stacey and other panelists have talked about, how do you, what's going through your head about how you're educating somebody that doesn't have that experience with groundwater?
And that's where the pre-filed testimony comes in, is that there's a lot of opportunity in the pre-filed testimony to do the basic educational part of it, but it's in writing. And that you lose a little bit, unless if you had live direct examination, you can actually get into teaching mode better. So there's limitations to all this. And that's where I was saying the technical report or expert report can dive into the specifics that are more, the audience is there for more for the other side's experts, rather than the judge. The judge needs to have some understanding or basics, and that's where the pre-filed testimony can actually, you take some time and actually do some educating in that document.
Right, so let's segue to the hearing itself. We're all prepared. The hearing isn't an event on a day. It is an event over months. And so Stacey, if you could talk through a little bit just conceptually on what the event looks like. For the room, if you could talk a little bit about like what it means when we talk about discovery. We've mentioned pre-filed testimony, like what that is, and kind of sequencing wise, what are the various steps and generally how long it takes.
Sure. So between the preliminary hearing and the merits hearing, which is basically a trial, they don't call it a trial, but it is a trial. It's basically a bench trial with, a non-jury trial, which we call in the litigation world a bench trial with a judge. But it has, other than the pre-filed testimony, which is submitted in advance, it has all the components of a regular trial that you would see on TV, just without the jury being there. So you have cross-examination of witnesses, you have redirect of witnesses, But the discovery period happens before the trial or the merits hearing. And that can involve written discovery, oral depositions, requests for admissions, requests for production, which is documents. And I think discovery can be very effective and cost efficient if you know up front what you need to prove, what evidence you currently have to prove it, and what you need in discovery. And then you send very targeted discovery for what you need, not just like, I'm going to send discovery for the sake of sending discovery, because that can get really expensive. But discovery is the mechanism by which you get the additional evidence that you need. You're going to want to depose all the experts if you can. Sometimes there are cost limitations, but I'm going to want to know what Dr. Hutchison is going to say about, if he's representing the district or the protestant and I'm the applicant, and I'm going to want to be able to question him about his expert report, or if it's provided in advance. And it just gives you an opportunity to prepare your evidence, hear the other people's evidence, and sort of prepare your rebuttal evidence to that, all in anticipation of the event, which then, involves calling witnesses and then being subject to cross-examination. And you have expert witnesses who are technical witnesses that are going to talk about science, and then you have lay witnesses or maybe, client representatives who are going to talk about factual issues. And going back to, sort of telling your story and what's persuasive to the judge, I think visuals are hugely beneficial for people who are visual learners, but also for very technical things. Showing exhibits about, the design of the well field, for example, with respect to, existing wells nearby when you're talking about impacts. That visual representation of that can be hugely beneficial for everyone involved. So I think, you've got this written stuff and the reports, but you also need to translate that. We heard talk about data, and we saw that slideshow where it took the raw data and then it iterated it into something that made sense. That's the same thing you're doing with your evidence. And you've got to streamline it and make sure that you're telling your story and that people can understand it.
And let's talk about that. And Stacey, I appreciate that you've likened the process to what folks have seen on TV. And Jim and Bill are going to comment on that a little bit because they get to enjoy being on a hot seat. They're the ones that Stacey calls to the stand, either because she's their witnesses or because she's going to cross-examine them. So Jim and Bill, if you could comment on what it's like being in the hot seat, and we're not talking that you're prepared. So what are your thoughts about you're stepping up and you're trying to convince one or two judges of what's right or wrong. And Jim, let me start with you. You've been on the hot seat quite a few times.
Playing dodgeball blindfolded, that kind of comes to mind. It's one of those things, it doesn't seem to matter how well you're prepared. It's going to feel like you're not prepared, you're not ready, and all you can do is answer to the best of your abilities. I definitely feel like I gave blood every time I get done testifying because my blood pressure has dropped by about 30 points from the time I started. It's a challenge, but it's not an impossible thing. And Bill, you've done this so much more than I have. Maybe you're listening to me and going, rookie. But maybe Bill has a better perspective on that.
Well, the one thing that's unique about these SOA hearings is the number of parties. Usually you get involved I've been involved as an expert witness on some cases where there's just two parties. And the contested case hearings in SOA are unique because there's pre-filed testimony. And so your testimony, your live testimony, you're being attacked by 7 or 8 different parties on a cross-examination. And so it sort of is a different way than usually you can get warmed up in direct examination, explain what you did and how you did it, and essentially get into a rhythm. And all of a sudden in these contested case hearings, you're sitting there, you've got a couple of binders in front of you with your pre-filed testimony, and the hard questions start immediately. So it does present a challenge, and it's unique in comparison to some other expert witness type environments that you might find yourself in.
So we're in the heat of this battle, and we're supposed to share with the crowd how you navigate this journey. There are times during any trial where there is a eureka moment among everybody who knows what's going on. And I mean when the applicant and the protestants who are sophisticated looking at each other saying, oh my gosh. And sometimes, and many of us up here have had some experience with a judge who has said, okay, we're going to take a break, and I want you all to step out in the hallway and talk about settlement. So I'd like, we only have a couple more minutes on this particular topic, but I'd like for you all to share your view about how once you're in the heat of battle, that doesn't necessarily mean that the parties, it doesn't mean that we're going to fight it out for years. And talk about how it can be wise to leave the door open for discussions and having a professional working relationship with your opponent. Stacey, Bill. Stacey and I we've settled a case in the heat of battle.
Only because my client agreed to pay you millions of dollars.
Because you were sucking us dry, and we got it done. It was a win-win.
Here, wait, now it's on.
Money
My
talk.
client's in the room. She's pleased.
Yeah, I mean, obviously, it's from a technical perspective, if there's some common understanding of what the potential impacts could be, how to deal with it, there's always a chance for settlement, whether it's feasible from a financial or political perspective. That's always a different question. I mean, I'm involved in attempting to settle a very big thing right now that I can't get into, but it's a process, and it can be as expensive and, mind-numbing as hearings can be. So it's just a matter of whether there's, my experience, if there's the political will to settle something, it can be settled. If there isn't, the hearing continues.
We've got just a few minutes. Let me move on to that. We'll settle it afterwards, Jim. Let's talk about this thing that we call a PFD. Everybody on this panel knows what the acronym stands for, and you'll hear it from whoever wants to go first. But I'd like to talk about what the reaction is from your clients, whether it's the Groundwater District's general manager, the applicant, the protestant. When you get this recommendation, it's what, a paragraph or so, right? How long is the PFD? What is it that Blayne receives when this referral that she's asked for comes back to her? So we've got about 3 or 4 minutes to talk about the proposal for a decision and how folks react to it and what remedies you have to be critical of it if you're not pleased with what the judges are recommending. I know you all have
It's
something
usually
to say.
very long. So it's like the client's like, what is the net? Tell me, did we win or lose? And it's like, I'm not sure yet. I'm only on the first paragraph. And unfortunately, they didn't lead with the conclusion. So
How many pages?
Hundreds in some cases. So it takes a while to get through it. But once you realize who won, who lost, or whether there was, a parsing of that, you win on some, you lose on others, then it goes back to the board, and the board, Blayne's going to ultimately be deciding, whether there's going to be any changes made to that. But it's like, what is this, and this is what I paid for. Tell me what it means.
Jim, your district paid for a few of those, and you've read the hundreds of pages. Observations?
It's like any other judicial ruling. So it's one of those things where you kind of wade through it, and yeah, you're definitely going through paragraph by paragraph, going, okay, it's good, it's bad, it's good, and then, ultimately you get to the conclusions and realize, or maybe you cheat and you just flip directly to the last page and start there. It's
Last pages.
pages. Yeah, I'm sorry. But ultimately, you get. It is just a recommendation from the judges. It's a very strong recommendation, but it is not necessarily the final word, and it's always going to be up to your board to look at that recommendation and figure out how they want to implement anything that's found within it, within the bounds, that are available to them. So I think that might be a good time for.
So let's talk about this. Blayne, you handed that baton over to Shoah, and unlike track, the sport, they hand it back, right? And so this proposal for decision and accompanying findings of fact and conclusions of law that often are 100 pages plus or minus, they come back to you. And before we start with you, Blayne, Stacey, I'd like for you to talk about that bridge. So SOA, literally, they email it back over to the district's, probably whoever the board designated as the contact person, and that's probably you, as say, the lawyer for the board. Legally, what are your board's next steps?
Well, we're going to have to look at it, but eventually they are going to ultimately be scheduling the final hearing on it. And that's where they're going to be making a determination on, okay, yes, we're going to give a thumbs up to the ALJ, or we're going to give them a thumbs down, and what are we going to change? And that hearing can be continued like other hearings, like the preliminary hearing can. And then hopefully, your lawyer's giving you good advice about here are the limited circumstances in which you can change the proposal for decision, and you're starting to identify whether there are some potential areas for that to happen. Sometimes you have things that are very, that were mistakes and errors, and it's kind of uncontested and undisputed, and the parties can kind of agree, hey, we can change this word here, or that's a typo or whatever, but that's all pretty easy. But whether or not the ALJ improperly applied or interpreted the law, the rules, or decisions is really the crux of what the board is deciding.
So let's come back to Jim and Blayne, who have had some different experiences with how you're handling things before the board. And Jim, let me start with some of your more recent experiences. There's some judgment calls that your board makes about whether you want to hear from the applicant or the protestants, or whether your board even wants to hear from you, what else, in person orally. Whether your board is going to take remarks from the parties, oral argument we call it, whether there's going to be additional written briefing, or whether you're going to allow the dozens, if not hundreds of people who care about this but who are parties want to show up. You sometimes are trying to figure out, are we having this at my office, or am I renting the convention center for the next stage? Literally. So thoughts on how you make those decisions and advice for the crowd.
So, in that process, we've got, obviously, one of the first things that comes up with our board is, the possibility of remand, where if you feel the question's not adequately addressed by the PFD, to send it back to the ALJs and have them reevaluate that. But once we've moved kind of through that process, and we go through the exceptions and the exceptions to the exceptions and the exceptions to the exceptions to the exceptions, and we have something that's coming close to a finished document, then that's really a question that we work through with the board with regard to what that last step is. Do they want to have another round of oral argument, or do we want to say the PFD is now closed, this is what we're working off of? And at that point in time, you can bring in public comment, but the record is closed, the file is written. It's, you need to make clear that people understand that if they are coming in to give public comment, at that point in time, it's really just, yay or boo for the judge, because nothing else is really going to make a difference at that point.
So Blayne, you can call the shots on some of these options that you have, or you can ask your board to pass a motion. Hey guys, how do you want to handle this? I don't want to get in front of you board members, because our constituents are in the room. How do you talk through that, and kind of what are your thoughts for this crowd on what's best for your constituents and ultimately making a defensible decision?
Yeah, there's a lot going on at this point, because after I had passed off the baton, or the board passed off the baton, we had to leave the stadium. And we,
the state?
The stadium, because yeah, maybe the state. But we had to leave the stadium where that hearing, I'm using the race analogy to represent the hearing that everybody else was working on. So when SOA brings that baton back to us, it's a fire hose of information that the board has to catch up on. And so, that requires the attorneys to give us the rundown on it. And so the board has a separate attorney. And so as we are looking at that, that's legal advice. We're going into executive session to discuss the fine points of that proposal for decision. Executive session, you can't do any action, so we do need to come out in open session to determine if that proposal will be remanded, if we will accept the ALJ, or if there's other decisions we will make.
So we have 6 minutes, and Leah, we're going to stay on time. And I have a question for Stacey, and it's going to segue into our takeaways. But still on this topic of how the board is vetting this. Okay, put yourself in the shoes of counsel for the board. And be clear about what you can and can't talk about in executive session briefly, but let's talk about special permit conditions, which is often the discussion. Because you got, 3 options. Grant in its entirety, give the applicant what they asked for, deny in its entirety, don't give them anything, somewhere in between. And the somewhere in between often comes down to conditions, some that are imposed involuntarily, some involuntary. If you could comment on that, bearing in mind that we're going to move into takeaways. I know the panel has some thoughts on that, and that's an important issue.
Sure, I think, typically it's not an all or nothing and you end up getting some modification. And so it's going to involve special conditions. And I think districts need to be really careful about what special conditions they impose. Is there statutory authority for the condition that you're seeking to impose on the permit? Is there a legal basis to do it? And are you doing it in a way that is kind of ad hoc, where maybe you're unintentionally discriminating against exporters because it's a large export project? Or are you in some way holding this permit applicant or a group of permit applicants kind of solely responsible for achieving the DFC? I think there are ways to use those conditions, but you have to be careful about it and be thoughtful about it. And then in terms of executive session and deliberation, you can't deliberate extensively in executive session or really at all. I think you can go in there and get your legal advice and then come back out and have your discussion in front of the public. And it makes people feel better if you give a reason. If you're going to be changing the PFD to provide, some rationale for doing that, state that you're going to do it. And you don't have to go into detail about it, but at least let people understand that there was some reasoning behind this decision. I think later when you ultimately adjust the PFD, you'll get into the nuances and details of the changes being made. But my advice is to have some sort of discussion, and the lawyer can help give you a roadmap, not a script of what to say, but like a roadmap of the elements that will guide the discussion and the deliberation by the board in the open meeting.
So I'm going to open it up to the panel. We've had some conversations about things that we wanted the audience to leave with as they walk out of the room, back to their homes and offices today. We've got probably another 3 or 4 minutes. Y'all share your thoughts on some of the takeaways that you like to leave with this crowd.
Well, from a technical standpoint or expert witness standpoint, the basic message is write your reports, know your if you're doing a deposition and before the hearing, know that deposition's inside and out, so you're able to effectively communicate what you've done in the context of the questions being asked.
I'll go next. I think it's true for whether you're the applicant, the district, or a protestant, or the general manager, arguably, and then the board, or the protestant, is just be prepared. Don't underestimate your opponent. Know what you're supposed to prove. Get all your evidence in. Don't ignore weaknesses in your case. I've seen it be devastating when there's a weakness in the case and the applicant knows about it but doesn't address it, and then it can, be fatal. So prepare your rebuttal evidence and make sure you get it all on the record.
From the board perspective, the time that it would take the board, I feel that SOA is a really good alternative for a hearing, just because it removes that learning curve from the board. But what can't be forgotten is how much time it's going to take a staff, because they still are a party to that contested case. So although the board has referred the hearing to SOA, staff is in the weeds.
Thank you. I really appreciate you saying that. I'll follow on, in support of using SOA for these contested cases. It is a lengthy process. It is not a cheap process, but it is a way, especially in a highly contentious application or highly contentious, permit, to really drill in, get evidence on the record, and come to a conclusion that I think, if people may not necessarily like it, but at least it is a decision that people will understand how it was arrived at. Especially if you follow on after the PFD by having those board discussions that Stacey mentioned, and having all of that, between the evidence developed by the experts, the process that goes through SOA, it's not necessarily a consensus building activity, and it's certainly not fun, but it is a way, I think, to address a lot of the uncertainty and a lot of the angst that can develop around some of these large permits.
Leah, our MC, thank you for inviting us as your final panel. It's been good being with you at the end of the conference. I hope we met the objectives and left some value with the folks in the room.